Hello, everyone. We're going to talk about navigating reverse discrimination and the concerns by people who think they're subject to reverse discrimination because of DEI measures. And this, of course, is a very interesting topic in these days, considering what's going on in the US and so on and so forth. So for this podcast today, besides myself, Carl-Frederik Hedenström, who is a labor lawyer in Stockholm, Sweden, I have with me Claire Dawson and Camille Olson. Claire from the UK and Camille from the US, and I will let them do their introductions when they get the first question. So before sort of going into the subject matter, I would just like to start just like we did when we had this presentation live in London a couple of months ago, to give you some food for thought, and that is, what is really equality or people being treated equally? There's actually a difference there, at least I think. And I've heard this being described by a person that works with the DEI questions, which of course I don't do in that as a professional as such. And he gave me this example. Let's say that you're a big football / for the US audience, soccer fan, and you want to go and see the Arsenal games like I do sometimes. And for some reason, some security reasons, Arsenal decides that they're going to put up a fence in front of the spectators, just for security reasons. And this is going to be a solid fence. You can see through it. But they looked at the average height of a person going to a football game, so they put it at 170 centimeters, something like that. Most spectators will be able to watch over the fence. Everyone that goes to the football game will be treated equally. The same fence, you're standing behind the same fence. But if you're below 170, you won't see a thing. So, in other words, you're treating everyone equally, but is that really equality? Now, well, if you give someone a box, sort of, if you're below 170, then if you give someone a box, you put that person on the box, and you can see over the fence. That's actually being treated equally then, or being equal in that sense. So there's a big difference there. And what I'm thinking about sometimes when we talk about DEI is that, what people that wants to get rid of DEI wants really is to get rid of the box. And is that really fair? So that's sort of something to think about for today's presentation. So I'm going to start with Camille, who's a distinguished lawyer from the US. And together with introducing herself, I want her to sort of elaborate a bit about how US laws and government enforcement priorities currently address claims of discrimination by majority group individuals, and how does the legal framework apply to US-based corporations with global operations? So that's a big subject, but still, Camille, please.
Thank you so much. I appreciate the introduction that you've given the discussion, as well as both Claire and me. I'm a partner at Seyfarth, which is a global law firm. I chair the U.S. Chamber of Commerce's Equal Employment Opportunity Committee, and my own practice is one that is divided between counseling, outside investigations, and trial work. Much of that work is related to claims of potential violations of U.S. laws as they relate to non-discrimination, non-retaliation, and non-harassment. In connection with the question that you raise, the guiding principles that regulate the workplace in the United States have not changed for many, 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 many years, for decades. The U.S. Constitution, which applies to certain action, requires that individuals be treated equally. It's called the Equal Protection Clause. Section 19, and that went into place obviously a very long time ago, hundreds of years ago. Section 1981 of the Civil Rights Acts of 1866 went into place a couple of hundred years ago, and it requires that with respect to any contract, and that is with respect to a contract for an independent contractor, a contract for a consultant, or any employment relationship, that an employer is prohibited from taking into consideration or treating differently somebody in connection with that contract based on their race. And in 1866, race was defined very broadly to include anyone's national origin. So we think of Section 1981 as covering both race and national origin. The other law that is the most relevant from a federal perspective, which covers all of the states in the United States, is Title VII of the Civil Rights Act of 1966. So we're going back many, many years here, over 50 years. And that law, which is really the bedrock, Title VII is the bedrock of non-discrimination law in private employment in the United States, states that every individual, and the language of the statute and the language of very recent Supreme Court cases in the United States, including one from June of this year, have said, you really need to focus on that language. Every individual is entitled to not have an employer take into consideration their race, their national origin, their religion, their gender, or their color. So there is no reverse discrimination in the United States. There is just discrimination. And taking into account any of those attributes in determining who to give a box to, in your example, as you led off today, would be discrimination if that box is seen as a preference or the grant of a benefit. So in the United States, the laws have not changed. Those are really the laws, federal. Then you've got state laws that also apply depending on the local jurisdiction in which the worker is working. And state laws can be more expansive, but they cannot take away the rights of federal laws in the United States. So what I would say is what we have with our new administration and President Trump's policy priorities and enforcement priorities are a focus on, in fact, ensuring that no one is a subject of discrimination coming from any camp based on one of these protected statuses under Title VII or under Section 1981. And in that regard, there's been an enormous amount of activity in the United States, from executive orders to technical assistance being issued, to settlements, to lawsuits, to public naming of various individuals and employers regarding allegations that have been raised that they in fact have provided preferences or workforce balancing or have in fact discriminated by giving certain individuals preferences because of one of those protected statuses. And one question I know some may ask if they attended our presentation back a month or two ago is, have there been any changes in the United States? And the answer is yes. There literally are changes in terms of the enforcement priorities and more specificity in terms of DEI compliance with the law in the United States, literally every day. And I would say that the most recent one that came out that's significant was on July 30th, when the U.S. Attorney General released a memorandum to all federal agencies that's entitled Guidance for Recipients of Federal Funding Regarding Unlawful Discrimination. So in the United States, the focus today is, from this administration, on ensuring equal opportunities for all and ensuring that any company efforts to support inclusion, to support diversity, to support equity are not running afoul of the requirements of U.S. law, which don't allow, outside of the areas of the Americans with Disabilities Act, which require reasonable accommodations or certain religious prohibitions and reasonable accommodations that are required. These other statuses, whether it's sex or it's race or it's color, do not allow for affirmative action obligations or opportunities for employers, except in very, very, very discrete, very fact-specific circumstances. So in the United States, right now what's happening is there's an enormous amount of work with respect to reviewing, identifying, reviewing, and evolving, if necessary, current practices and initiatives to come into compliance if they aren't already, or to eliminate any ambiguities in terms of language. So, for example, many companies are looking at the words diversity, equity, and inclusion and saying, I'm going to define those terms. So, and I'm defining them the way we're using them, so that there's no misconception that we might be doing something that's unlawful, or is a preference, or exclude someone based on their protected status.
So, Claire, after listening to Camille's very interesting description of where we are with reverse discrimination in the US, and there's actually nothing like, and the fact that there is very little affirmative action, contrary to what you might think, actually, if you're not living in the US. How has the law and practice in the UK addressed complaints of discrimination by individuals who believe they've been treated less favorably because of diversity targets initiatives? Do you have anything like that in the UK? And please also, Claire, please give us a brief introduction to your what you do and where you work.
Thanks so much, Carl. I'm a partner at BDBF Employment Law in London, and I primarily act for individuals. So I think the starting point here is, as in the US, there's no such thing as reverse discrimination as a separate category in the law in the UK. The protection from discrimination is symmetrical across all the protected characteristics, apart from disability and pregnancy. Positive discrimination is not lawful in the UK, but what we call positive action is. And there are two types of positive action that are permitted by the Equality Act, although neither of them is required by law. So it's up to an employer whether they decide to do these at all. And the first type is pipeline positive action. That's what I would call it. It's about getting more people onto recruitment slates, holding open days, providing support and mentoring. So increasing the pipeline of candidates from underrepresented groups, let's say. And the second type is what I call tiebreaker positive action, which permits preferential treatment of a candidate from an underrepresented group where there are two applicants who are as qualified as each other. And you can imagine that's something that's quite difficult to assess sometimes. There's only one case in the UK on pipeline positive action in the employment sphere. And this was where there was an engineering training program that was reserved exclusively for women. And that was held not to give rise to unlawful sex discrimination, but was held to be a proportionate positive action measure because it didn't give any guarantee of a job at the end of it. And the recruitment process for roles was an entirely separate exercise. Plus, in that case, the tribunal said this was given as an example by the Equality and Human Rights Commission's Code of Practice in Employment Law. And they'd specifically said this type of program was an example of lawful positive action. There are only 2 reported cases on the application of tiebreaker positive action, and both relate to police forces in the UK. And that won't be surprising to anyone who understands the context of policing in the UK and the desire to increase the diversity of the police force to match the diversity of the populations they serve. So in the case of Furlong, having used pipeline positive action measures to very little effect, Cheshire Police decided to use tiebreaker positive action. So they had a 3-stage recruitment process. After the 3rd stage, a candidate either passed or failed. There were 127 candidates who passed, and there were 85 positions available. And at that point, the police force applied the tiebreaker. So that meant that anyone within that 127 who was from one of the underrepresented groups was automatically offered one of those 85 positions. And Mr. Furlong was a white heterosexual man, and it meant he got pushed down the list. He didn't get offered a position, and he won his claims for discrimination. The tribunal said Cheshire Police had legitimate aims, but found that they'd acted unlawfully by just scoring a pass or fail at interview stage and treating that as a tiebreaker, because actually they'd gathered extensive information about each candidate during the recruitment process and could have done a much more nuanced assessment. So that approach was disproportionate and therefore unlawful. The other case concerned the promotion of it within Thames Valley Police of a sergeant to the role of detective inspector without any internal advertisement or competitive selection. And that was part of the force's aim of fast tracking officers from ethnic minority backgrounds to detective inspector. So 3 white sergeants who had expressed an interest in opportunities for promotion brought claims of direct race discrimination, which they won. But probably what the most well-known reported case of reverse discrimination in the UK in the private sector is the case of Mr. Bayfield and Mr. Jenner, and they were both creative directors at an ad agency. And in 2018, the ad agency's gender pay gap report had revealed a gender pay gap of 44%, and it was the highest across the advertising industry that year. So it was very embarrassing for the organization. And their pay gap report noted that this was because a majority of senior jobs in the creative department were held by men. So there was then an internal presentation about how the company was going to address this. And they said they were looking to recruit new female talent and that they wanted to ensure that new female talent stayed with the business and rose to the top. And they said they were going to obliterate the company's reputation as being full of white, British, privileged, straight men. So, as you can imagine, a lot of people were left feeling pretty uncomfortable after that meeting, including Mr. Bayfield and Mr. Jenner. And around the same time, there was a redundancy exercise in the business, and both men were made redundant. And ultimately, they won their claims for harassment, sex discrimination, and also victimization. And the tribunal concluded that 2 women who had raised concerns about the presentation, as they had, as the two gentlemen had, wouldn't have been treated the way they had. And they also said, quite simply, if they had been senior female creative directors, they wouldn't have been selected for redundancy. So it was kind of clear-cut discrimination, direct discrimination. So I think based on the limited number of reported decisions, all of which are first instance, I have to highlight, it seems employment tribunals in the UK are pretty sympathetic to the concerns of those who've been subject to reverse discrimination in inverted commas because of diversity targets. But I mean, as with any type of discrimination claim, including claims from traditionally underrepresented or disadvantaged groups, the big thing with a discrimination claim is evidence. And in these cases, there was evidence.
All right, thank you, Claire and Camille. I would just like to make a few points about Sweden then, which of course is an EU country, so we'd be pretty similar throughout the EU when it comes to these sort of questions. We don't really have any affirmative action in Sweden either. There's been some sort of policies to try to promote gender equality, of course, and that's also been true when it comes to, for instance, boards of private companies and the like. But it's not been no hard law. It's been policies, but nothing besides that. When it comes to case law, it's just like in the UK, there are very few. And out of the 2 or 3 cases that the Swedish Labour Court has decided, the thing you can the conclusion is that you cannot discriminate either way. There's no difference between regular discrimination and reverse discrimination. You can, in very specific cases, just like Claire described, if you have two equal candidates and one, for instance, is a woman or from a minority group, you might have reason to sort of pick that person because of equality or DEI reasons. But you cannot sort of pick a less qualified person just because they are from a minority group or if they are from sort of a underrepresented gender or something like that. So that's pretty much a conclusion in Sweden as well. So having heard this both from the US and the UK, I think a lot of what we're hearing today is not really about changes to the law or anything like that. It's just about changing how things are described to the general public when it comes to how different legislation works. We're going to turn over now to our second set of questions to the panelists. And the first one for Camille is, in the light of all these developments, how are multinational companies adapting their DEI and workforce initiatives to remain compliant across jurisdictions while continuing to advance their business and inclusion goals? So please, Camille.
Thank you. It's a complex question because there are certain local laws outside of the US, whether they be in Canada or they be in Europe or any country, that may require certain affirmative actions and reporting regarding diversity opportunities, and may also encourage or require an employer outside of the US to use as a factor in decision making somebody's sex or somebody's race. So what companies are doing is looking at, with respect to those requirements, there has to be a question as to whether you can harmonize, first of all, what those requirements are outside the US with any US requirements. Sometimes you can. And if that's the case, a general policy that applies outside the US can also apply in the US. If it cannot be harmonized, companies are looking at their programs, their policies, their decision-making, the relevant factors that are being used, the due process that's provided to individuals in connection with decision-making, and determining whether actually US law is going to apply and it's going to be different. So for example, a foreign-based company that is controlled and operated outside of the US, but employs individuals who provide services in the US, are going to be required to comply with US law with respect to all of the decision-making with respect to those individuals who perform services in the US, whether or not they're US citizens, if in fact the employer has at least 15 employees anywhere in the world. So that's one example. And then, when a US citizen is providing services for a company that is outside the US, there are other rules that apply, but those are now being invoked and paid attention to much more so than before because of some potential issues. And I should mention that Title VII does have an exception with respect to US employees who are performing services outside the US. If there is a conflict with local law and their services are performed outside the US, the local law will, or a treaty that's directly applicable, may provide the answer as to which law will apply. So it's a very technical issue. The facts matter. And also, when I say the facts matter, the nationality in effect of the company, who's controlling the company, the citizenship of the individuals, and where they are actually providing the services, and whether there's an ability to harmonize the laws between the US and the second country, or whether in fact they are not able to be harmonized, and then whether the local jurisdiction exception would apply.
Thank you. sometimes I wonder if the current administration is, I would put it, not qualified maybe, but sophisticated enough to sort of appreciate these sort of points that Camille is raising. But that was my personal thought. Thank you, Camille. That's really interesting. And before I turn this over to Claire again, I would just like to sort of give you one small anecdote again here when it comes to how these DEI, how to interpret DEI and what that could might lead to. And this is more on the funny side of things, if you think these sort of things are funny anyway. Just a couple of months ago, there was a letter going out from the US Embassy to the Stockholm municipality, where they said that, and I think these sort of letters have been sent out in multiple countries, it's just not Sweden, where the embassy told the municipality that unless they scrapped all their DEI initiatives, they would rescind or terminate all contracts between the embassy and the municipality. Well, if you want to do things like that, you should sort of strike from a position of strength, I think, which in this case, the embassy did not have. Because what does the municipality of Stockholm provide to the embassy? Well, they provide garbage collection, water, sewage, and all these sort of common utilities. So in other words, the comment from the municipality was, you'll go ahead and terminate the contracts and you can pick up, and the ambassador can pick out his own trash. So, there's just that much that even if you want to scrap all DEI throughout the world, you cannot sort of reach everything. So I think that's kind of a funny story. But having said that, let's go back then to Claire and what has happened in the UK as a result of the DEI rollbacks in the US. Are there any diversity measures that are actually required by UK law?
Well, I think just to answer that sort of briefly, the rollback of DEI in the US has certainly had an impact in the UK, but I don't think it's remotely mirrored what has happened in the US. I mean, there have been some changes that we're seeing across business. So I know BT removed its DEI targets from its annual bonus awards for middle managers, but it retained them for the top senior leaders. Lloyd's Banking Group announced the reduction of diversity targets just earlier this year, affecting annual bonus awards for senior staff and wider employee population. WPP removed all references to DEI from its annual report, which was published in March of this year, compared to over 20 mentions of DEI in the previous year. So you can see the sort of very, very swift culture shift there. And Accenture, in February of this year, announced various changes to its global DEI strategy, including in the UK. And it said that those were triggered by the executive orders in the US. So it's going to sunset diversity targets, along with career development programs for people of certain demographic groups. And Transport for London, which is the organisation that runs our tube and bus network, and in fact, all of London's transport network, has now blocked Accenture from bidding for work for them as a result of this rollback that they've announced. Our financial regulators, the FCA and the PRA, abandoned rules they had proposed, which were aimed at improving diversity and inclusion in the firms that they regulate. And they were geared at mandating firms to report on diversity metrics. Now, what they've said, though, is that there's going to be legislation in this area in the UK on reporting certain data, and they didn't wish to overburden employers by bringing in their own data reporting requirements shortly before there's new legislation for reporting certain diversity data. But the head of the PRA reiterated that an appropriate focus on diversity and inclusion in the culture of regulated firms would deliver improved internal governance. And certainly the FCA and the PRA have made clear in the past that a good workplace culture, which maintains diversity and ensures that there's that is against harassment and bullying in the workplace is good from an internal governance and decision making and risk management point of view. Because a good workplace culture means that people aren't afraid to speak out if things are going wrong. So I think because UK employers operate in quite a different legal and political and cultural framework, it's likely that DEI measures are going to be insulated from a wholesale rollback, at least in the short to medium term. We have a Labour government that was elected here in the UK in the summer of 2024 with a legislative agenda of developing and strengthening equality law, and they are rolling their new equality provisions out. On the other hand, we also have Reform UK, a right-wing party which won a large number of seats in local elections this year and has vowed, among other things, to end DEI. In terms of, another category of claim that we may see arise encouraged by the kind of anti-woke DEI backlash in the UK, we've seen, because we have protection in the UK from discrimination based on philosophical belief as well as religious belief, we have an increasing amount of jurisprudence on that type of claim. And we've seen one claim already from an employee who said his objection to his employer's support for the Black Lives Matter movement resulted in him being suspended. And it being suggested that he must be racist because he didn't support BLM. He lost his claim in that case because the tribunal found his beliefs were not protected by law because BLM itself lacked the cogency and coherence to be considered a protected belief under UK law. And the corollary of that was that a lack of belief in BLM was also not protected. But in another case against ACAS, which is our statutory conciliation body for employment complaints, a Mr. Corby posted criticism of critical race theory on Yammer, and following complaints by colleagues, he was asked to take those posts down. He claimed that that was discrimination on the basis that he was opposed to identity politics. And the tribunal in that case held that his opposition to critical race theory was a protected belief, but in that case, he had not been subjected to any direct discrimination or harassment because of it, and that the employer had acted proportionately. And my understanding is that decision is subject to appeal. So I think that's an area that's ripe for further cases to be brought, because we're seeing a huge number of cases being brought in this general area of employees complaining that they've been discriminated against because of their philosophical beliefs.
Thank you, Claire. I think we're sort of in different stages of this development in different countries, which is kind of interesting. This has not been a huge issue in Sweden recently, I must admit. We've been very, very sort of aggressive on driving sort of discrimination laws to not discriminate against gender, sex, beliefs, religion, and all those sort of age and so on and so forth. But we haven't seen the same backlash as we for certainly see in the US right now. And I don't think we will get there. Our right-wing parties are not pushing the woke agenda. You need to talk about it a lot that hard. I don't think they will win many votes on that in Sweden. But anyway, thank you very much for all these insights. It's been very interesting, and hopefully it'll be worth your time listening to both Claire and Camille, and to some extent me as well. Thank you.